Now, we will discuss the Tenant Selection Plan Addendum, an important part of the application process for Ohio 811 program units. Upon submission of an application, the property manager fully screens the applicant according to their procedures and within the requirements of the TSP Addendum. This document provides guidance to property managers regarding procedures they must follow when processing applicants for program units, and addresses barriers the target population may encounter, including those associated with criminal history, credit reports, and previous rental history. The TSP Addendum also sets forth the process for applicant denials and the appeal process. It is the responsibility of the owner and property manager to ensure that all provisions of the TSP Addendum are enforced, and where there is a conflict with the property TSP, the addendum will prevail. The TSP addendum includes the 4 disqualifying criteria that are required for all HUD programs, including the Ohio 811 program. Individuals who have been evicted in the last 3 years from federally assisted housing for drug-related activity are disqualified, with exceptions if the evicted household member has successfully completed an approved supervised drug rehabilitation program, or the circumstances leading to the eviction no longer exist. Individuals who have been convicted of manufacturing methamphetamine on federally assisted property are disqualified without exception. Individuals that are convicted sex offenders and are subject to a lifetime registration requirement are disqualified from the program. Individuals may also be disqualified if they are currently engaged in the illegal use of drugs, or if the owner has reasonable cause to believe that the use of drugs or pattern of illegal use may interfere with others' rights. The TSP addendum also includes several mitigating circumstances for criminal history, background and credit reports, and previous rental history. HUD has issued guidance that provides considerations for housing providers related to the use of criminal history in tenant screening and the Fair Housing Act. HUD indicates that a policy that rejects applicants because of arrests without conviction is not acceptable. While a conviction can be evidence of criminal conduct, HUD encourages housing providers to distinguish between convictions for criminal conduct that indicates a risk to resident safety or property and criminal conduct that does not. In addition, HUD suggests that a tenant screening policy consider the nature and severity of a conviction and the amount of time that has passed since the criminal conduct occurred. Follow best practices for complying with all relevant laws in this area, including civil rights laws. Many housing providers use consumer reports, such as tenant background or credit reports, as part of the application process. The Federal Trade Commission provides guidance for housing providers who use such reports, and notes that if an applicant is rejected based on information in a consumer report, a notice must be provided that includes the name, address, and telephone number of the credit reporting agency that supplied the report, a statement that the CRA did not make the decision to reject the applicant and cannot give specific reasons for it, and a notice of the applicant's right to dispute the accuracy or completeness of any information the CRA furnished, and the right to a free report from the CRA upon request within 60 days. HUD also recommends a policy that considers mitigating information as opposed to a policy with strict time limits, which is less likely to be discriminatory and therefore less likely to be a violation of the Fair Housing Act. HUD recommends that housing providers adopt the following factors in their evaluation of an application: the facts or circumstances surrounding the criminal conduct and the age of the individual at the time of the conduct, evidence that the individual has maintained a good tenant history before or after the criminal conduct, and the facts or circumstances surrounding any negative factor related to rental or credit history, including items related to a previous lack of affordable housing or items unrelated to housing, such as medical debt. The TSP Addendum also requires property managers to consider any relevant HUD guidance statements, which are posted on the 811 Property Manager page of the OFA website. Some of these are referenced in the TSP Addendum, while others are added as issues and questions arise.